Good morning. Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeal in BZCV number 3 of 2023 between Wilfred P. Elrington and Progresso Heights. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge.
Good morning, everyone.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnathli.
Good morning, everyone.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamadar.
Good morning to everyone.
May we have the appearances, please? Thank you.
Good morning, Justices and Mr. President of the Caribbean Court of Justice. My name is Wilfred P. Elrington. I am appearing in person, and I am assisted by my junior colleague, Paulette Elrington. Paulette Civil Elrington.
Yes, good morning again, Mr. Elrington.
Good morning.
Good morning, Mr. President and Justices of Appeal. I am Priscilla Banner, appearing for the Respondent, Progresso Heights Ltd.
Okay, good morning again, Ms. Banner. Mr. Elrington, there was some, I gather, preliminary applications that you wished to make. Could you tell us succinctly what those are?
There was a single application, Mr. President, simply to correct some clerical errors on a notice of appeal. I have filed the application and the relevant documents supporting it, and I communicated with Ms. Banner yesterday on it.
I see. Okay. Ms. Banner, do you have any objections to the application?
Your Honor, I have read the application, and what I appreciate is that it appears to turn the appeal somewhat on its head, simply because what the application is seeking to do is to change the color of the appeal from one wherein the decision of the learned trial judge is being impugned to one where now we're dealing with the Court of Appeal decision. While I do admit that the Court of Appeal decision is the proper decision that ought to have been appealed, it does not appear to me that this was in fact a typographical error. It seemed to have been the clear intent of my learned friend to impugn the decision of the learned trial judge. In the circumstances, we object to the application, but we are satisfied with the court dealing with this issue on the substantive determination so as not to detain the court.
Okay, I'll tell you what we do. Mr. Elrington, you could spend maybe the first 5 or 10 minutes of your address to us, persuading us why this application should be granted. And then you will go into your substantive address on the basis that it might be granted, but also leaving a little room in case it isn't granted. What would be your position? And then we would hear from Ms. Banner as to what her objections are, and as well what her response is in relation to your substantive submissions.
Much obliged.
Much obliged, Mr. President.
So you may begin.
May I proceed?
Yes.
All right. My Lord, it will be seen that from the notice of application, the notice of appeal, the sections that we are seeking to amend were not clear, in that in one section we are making reference to the Court of Justice, High Court of Justice, Supreme Court, and the other section we are making clear that the decision is a decision of the Court of Appeal dated the 20th and the September 20th, 2022. also too, my lords, the entire process which ultimately resulted in the matter being brought before your lordship's court dealt exclusively with the decision of the Court of Appeal. In other words, special leave had to be granted to appeal against that decision. And the entire rule is dealing specifically with that decision. That is the decision that the Constitution gives the right to the applicant to appeal against. And the timeline within which the application was made was consistent with the rules governing appeals against the decision of the Court of Appeal. So the entire process related to decisions against the Court of Appeal, which is a constitutional right which the appellant had. It is only in the reduction of the application the errors arose. And I had been seen earlier on in the session. I had not been of the best of health and could not give these matters the kind of attention that maybe I should have been able to give it were it not for that. But outside of that, in other words, it is not possible for me to have appealed against the decision of the first instance court to this court. That is not what your rules provide for at all. The rules which we followed are rules which dealt exclusively with appeals from the Court of Appeal.
Are you, Mr. Elrington, appealing as of right, just to clarify that point,
Yes,
or
yes,
with the leave of the Court of Appeal? Which is
yes.
it?
This is an appeal of as of right with the leave of the Court of Appeal. It's a constitutional right given, but the process had to go through the Court of Appeal. We had to apply to the Court of Appeal for permission to leave.
So the Court of Appeal exercise a gatekeeping function. I think we said in some previous cases. Is that okay? All right.
That's it. And the guidance on that issue is exceedingly clear, provided by your lordship's court.
Okay.
So that it was not a matter which the Court of Appeal had a discretion to refuse. They had to grant the appeal. And
Understood.
so the entire process is consistent with an application as an appeal against the decision of the Court of Appeal. And it has nothing to do with an application by the trial judge.
And the appeal is one as of right on the basis of, is it the value of the land involved or an interpretation of the Constitution? What is it?
An interpretation of the Constitution, my lord. It's a legal matter. The legal point as of right is an application on a legal point, a very clear legal matter.
But do you mention the Constitution in your notice? Do you mention the Constitution anywhere in your?
In the application for leave before this Court of Appeal, yes, we had to make mention of it. We had to make reference to it, and that was done. Everything was done that was consistent with the law. The only area where we had some difficulty was in the reduction of the application. And you will see it's really only technical reference to the Court of Appeal. Sometimes we made reference to it, sometimes we did not. Then we made reference to the judgment, and then we did not.
Thank you, sir.
Yes, proceed, Mr. Elrington.
All right, Mr. President and members of the Court of Appeal.
I'm sorry, we are not the Court of Appeal, actually. So
it's Caribbean Court of Justice. Sorry.
Thank you.
Very, very sorry. You must understand that.
We don't want a demotion which we don't deserve.
No,
Thank
I
you.
very infrequently appear before this court and courts in general. So please forgive me. Please.
You are forgiven. No problem. Thank you.
All right. the background of the case, if I may go into the background, and let me say, your justices, that in the formulation of the arguments which we are about to present to this apex court, we have sought scrupulously to be faithful to the law and legal principles governing litigation by corporate bodies. We have sought to substantiate every material contention we put forward with relevant legal authorities. We are guided by the tenet that, as a rule, decisions of the courts are based upon the evidence and the law presented before the court. And we are mindful of the fact that the claimant respondent is not a natural person, but a fictitious person, and the peculiar factors flowing from the legal characteristics of a corporation. The law governing corporate bodies is of ancient origin. It is comprised of both statute and common law, which have been widely adjudicated upon in courts and common law jurisdiction the world over for centuries, including our own courts. The background of the case is that Progresso was incorporated, that's the respondent, in Belize on the 21st of July 2003. The appellant and two other persons, father and son, are the subscribers to the memorandum and articles of association. Father and son are the directors. The company's main objective is to sell land. On 18 November 2016, a claim was instituted in the Supreme Court in the name of Progresso against the defendant appellant, claiming damages on the ground that the defendant appellant had tortuously interfered with and/or caused harm and loss to Progresso by wrongfully lodging cautions against his land at the Registrar of Lands, Belize. It is worthy of note, however, that the record of appeal contains no evidence whatsoever as to who authorized the institution of the claim and how it was authorized. Not a scintilla of evidence.
But isn't that a matter for the defendant to raise?
My Lord, I will address all of that as I go along. I will address all of it as I go along. The defendant appellant in his defense alleged inter alia that the two directors of Progresso were fraudulently proposing to sell land, the property of Progresso, using Progresso's name without his authority, and were appropriating the proceeds of said sales among themselves, their agents, and puppet entities. And then in his judgment of November 11, 2019, the trial judge found in favor of Progresso and ordered the appellant to pay to Progresso special damages in the sum of $119,679.44 US, general damages in the sum of $1,000 per caution lodged, and interest on the special damages at a statutory rate of 6% per annum. I appeal against that decision. Now, the sole ground of appeal which I intend to argue before your lordships this morning is the ground that the decision of the High Court and the Court of Appeal are both against the weight of the evidence. The decision of the court are both against the weight of the evidence and the law. The essential contention of the appellant is that both decisions and orders made by the subordinate courts in this appeal are wrong in law. The appellant contends that the record of appeal in the instant case disclosed no evidence whatsoever that Progresso was before the court. The same record that was before the trial judge was before the Court of Appeal, and it is before your lordship. It contains no evidence that Progresso had delegated or entrusted any of its powers or authority to Lawrence Schneider whatsoever. It contains no evidence of any testimony whatsoever from Progresso. The same record that was before your lordships was in fact before the trial judge, as I said, and the Court of Appeal. The appellant is positing that that record does not indicate in any way, shape, or form that the learned judges of the courts below decided this case on appeal on the facts and on the law applicable to those facts. The claim. The appellant respectfully submits that the obligatory and mandatory burden of proving the claim rested exclusively on Progresso. The authorities indicate that the general principle is that he who claims must prove. Generally, although there are exceptions, a claimant must establish the existence of all the preconditions and other facts entitling him to the order he seeks, and those must be established before the defendant can be called upon to answer the claim. Lord Nichols of Birkenhead, in his House of Law decision in the case of
Mr. Elrington, can I interrupt you, please?
Yes, sir.
If a claimant brings a claim and you say the burden of proof is on the claimant to establish all of the formalities, example that go to locus standi and so on, right?
Yes, sir.
All right. So a claimant brings a claim and a defendant is aware of deficits in, for example, jurisdiction or locus standi or status, as the case may be. What does the CPR regime require of a defendant procedurally? Because we have rules that govern how litigation is to progress, and those rules are intended, among other things, to make the management of litigation effective and efficient. And so, for example, certain points, say we call them preliminary points, maybe, should be taken at certain junctures so that litigation proceeds, as I said, effectively and efficiently. So my question is, in the context of what you're saying, the burden of proof is for them to establish all preconditions, fair enough. If they're on the face of the record or known to the defendants have failed to do so or have not done so, what is it that the rules expect procedurally to be done, and at what point?
If I can nuance this a little bit, because it's the same argument. No, Mr. Elrington, let me ask you, let me nuance that question a little bit. Now, if there's a law or a rule that says a bankrupt can't bring an action, that a minor can't bring an action by themselves, or a mentally ill patient, somebody appears and they brought this action, are they required to say, I am not a bankrupt, I am not a minor, I am not a mentally ill patient? Is that a requirement on them, or is it for the defendant to first raise that issue that you are a bankrupt, you are not supposed to be before the court, or you are a minor, you can't bring this action without your mother or your next friend or something like that?
May I respond?
Yes.
Mr. President and Justices, I believe that as an officer of the court, even outside of the rules of the court, that as an officer of the court, if in fact that information is known to me, then I should deal with it before the matter comes up for hearing. I should deal with that. But in the instant case that we are dealing with, I had no way of knowing that Lawrence Schneider was not authorized to give evidence, or that the company had not done these preliminary obligations, because I had no connection with the company whatsoever. This was an issue that was raised during cross-examination, and it was raised simply in an effort to elicit clarity and proof. The only thing that Lawrence Schneider said was, I was duly authorized to make the witness statement. That's all he said. That is all in the evidence. And my simple question to that was, by virtue of what authority? That was all. Now, I had no knowledge what he was going to say, because all that information is peculiarly within their knowledge. It is not as if I knew that he did not have any authority. And the truth is, he had simply said, I was duly authorized by a resolution of the company. That would have been the end of that matter. So I had no way of knowing that fact.
So, Mr. Elrington.
Yes, sir.
Was this matter dealt with in a preliminary hearing before the main substantive matter was heard? Was it raised
which one?
In the virtual hearing?
I'm not clear on that. I'm not clear what.
You're on mute now, Mr. Elrington.
Mr. Burgess, Mr. Justice Burgess, I'm not clear on what you're asking, sir.
Yeah, yes. There was a interlocutory hearing in this matter. Was there, or am I wrong?
I don't remember, but I can tell you this, that there was no occasion prior to the trial when the issue as to the authority of Lawrence Snyder to give evidence arose. There was none.
So was there any occasion when you pointed the judge to the legal requirements for a
resolution?
Yes.
Yes, my lord, and I'm glad you're raising that because there was.
Yeah, sorry, just 1 second. At what point in time was that issue raised by you?
There was a preliminary application.
Well, that's what I thought.
Application was made on video link to give evidence by video link, and I raised the matter. I said to the court that a witness for a company cannot give evidence by affidavit on behalf of that company.
Didn't you also say that the company
for resolution?
Didn't you also say the company company had to give permission by resolution for the action to be brought as well? Didn't you argue that as well?
Pardon me, sir?
Yes. Didn't you argue at that stage that on the authorities, and I think you cited the authorities, yes, that the company had to give authorization?
I may have, Your Lordship, I may have.
And this is important because Mr. Justice Abel made a ruling on that.
Yes.
At that point in time.
Yes, my lord, and
that was prior to the main hearing, was it?
It was, and the authorities cited by me in support of my contention were literally dismissed by Mr. Justice Abel.
Yes, that's right. So wouldn't Mr. Elrington, if I may quickly, wouldn't that have been an occasion for you to seek leave if you were convinced? Because I get the impression you were convinced that Mr. Justice Abel in that ruling was wrong. Wouldn't you have to appeal that decision?
It was not my understanding that I needed to appeal that. My understanding, Mr. Justice Burgess, is basically that it is for the other side to prove its claim. And it was on that basis that I proceeded. And if you permit me to go through the authorities.
No, thank you. I think that your written submissions, you went through the authorities, and your use of the authorities was very convincing. All I'm concerned with is the time at which the decision was taken by Mr. Justice Abel, because it seems to me that that's going to influence your right to appeal that decision.
Mr. Elrington, if I may ask you, the judgment or the ruling of Justice Abel on that issue raised by Justice Burgess, my brother, is that something that is available to us perhaps Ms. Banner can also assist.
The ruling of, yes, I think that is part of the record.
At the interlocutory hearing, Ms. Banner, you wish to
Yes, Madam
direct us this?
Justice. Yes, Madam Justice. The page of the record is 2418, and that's where the ruling begins with respect to the application for hearing by video link. And there is a draft judgment that reflects almost verbatim the words here, but that judgment has the word draft on it. And as such, we did not feel that it was appropriate to file it with the court. But this is the ruling, and then the order relevant to that ruling may also be found in the record, the sealed order. And that is at page 2138 of the record. It's listed as tab 10 on the court list, the list.
Yeah, I know that you will get your turn, Ms. Banner, but am I hearing right that this was an application with respect to giving of evidence by video link?
Yes, Madam Justice. It was an application by the claimant, the respondent here, for evidence to be taken from Mr. Schneider by video link. And during the course of those proceedings, Mr. Elrington made an objection to the effect that the Progresso Heights was not before the court. Mr. Schneider could not give evidence, was not authorized to give affidavit evidence on behalf of Progresso. And as such, there was no evidence before the court. And essentially that evolved into an argument that there was not a proper claimant before the court. During the course of the arguments, those may be found at page 2340 of the record, going up to starting at 2330 of the record, going up to 2341. The arguments back and forth. In those arguments, we made it clear to the court that the defendant was not at the time challenging the capacity or authority of the claimant to commence the claim, but rather was only dealing with the issue of authorization of Lawrence Schneider to depose to an affidavit in the proceedings.
Ms. Banner, I know that you want, but I think we need to be fair to Mr. Elrington, because your turn will come. So, Mr. Elrington, if you wish to take it from there. Thank you, Ms. Banner.
Thank you, Madam Justice. Madam Justice, the contention, really the fundamental contention is that the court acts on evidence, whether it is at a video link application or a substantive application, the court acts on evidence. And if there is no claimant before the court can't have evidence. That is the position I was making in that application, and I am making it before your lordships. And from my understanding of the authorities, most of which are issued by the Court of House of Lords in the United Kingdom, that is the position in law. If you don't have a claimant, then you can't give a judgment in favor of that claimant, because it will be doing injustice to the other side. And the fundamental role of the CCJ, the Apex Court, and all courts is really to do justice. Now, my contention was then and is now that if there was no appellant, if there was no claimant before the court, there can't be judgment in favor of that claimant. And my lords, I would simply like to finish my submission, and then I can come back and answer your questions if you don't mind. Let me just run through the authorities to see the basis upon which I am making my claim. With your permission?
Yes, please. Yes.
All right. So I say, my Lord Nichols, Birkenhead in the House of Lords, in the case of RE, others, minors, sexual abuse, burden of proof, at page 16, wrote as follows. The general principle is that he who asserts must prove. Generally, Although there are exceptions, a plaintiff or applicant must establish the existence of all the preconditions and other facts entitling him to the order he seeks. All. It is not different from the case in a criminal case, where the prosecution has to prove all the elements beyond a reasonable doubt. In the case of the civil case, my understanding is that those same elements have to be proved, but on a balance of probabilities. That's my understanding. And this is what I understand Lord Nichols to be saying. It's my understanding that where a company suffers loss, the law is that where a company suffers loss as a result of an actionable wrong done to it, the cause of action is vested in the company and the company alone can sue. And at page 17 of his judgment of the House of Lords case of Johnson against Gore, Johnson against Gore, 2001, 1AC, the learned judge wrote as follows. The authority support the following proposition. Where a company suffers loss by a breach of duty owed to it, only the company can sue in respect of the loss. And in the same case, in his judgment on page 38, Lord Millett wrote as follows. A company is a legal entity separate and distinct from its shareholders. It has its own assets and liabilities and its own creditors. The company's property belongs to the company and not to the shareholders. If the company has a cause of action, this represents a legal chosen action which represents part of its assets. Accordingly, where a company suffers loss as a result of actionable wrong done to it, the cause of action is vested in the company. In paragraph 32 of the judgment of your lordship's court, this apex court, this court, in the case of Jeffrey Searsland, MD, Safarina Paz against St. Matthew's University, which was jointly delivered by Honorable Madam Justice Registrar and the Honorable Mr. Justice Burgess, it was stated as follows. From a long ago, as the 1858 case of Wave against Regents Land Company, the requirement of local standi has been a feature of the right of a claimant to institute action against a company. The basic tenet of the locus standi rule is that standing or the right or capacity to bring a claim against a defendant must be shown by a claimant. That right or capacity to bring the action must be shown before any issues on the merits of the case arises. In his judgment in the House of Lords in the case of Inland Revenue Commissioner against National Federation of Self-Employed and Small Business Limited, Lord Fraser of Tullibelton wrote at page 645 of his judgment thus. The question whether the respondents have a sufficient interest to make the application at all is a separate and legally prior question which has to be answered affirmatively before any question on the merits arise. This principle is followed in the decision of this apex court in CCG appeal number BZCV2023/002, BZ Civil Appeal number 10 of 2012, Progresso Heights Ltd against Spitz and Elrington, Wilfred Elrington, in which the Honorable Mr. Justice Hayton wrote in paragraph 12 of the judgment of this court as follows. Legal J finished hearing the case on the 20th of January 2012 and expeditiously delivered judgment on the 20th February 2012. As to legal technicalities, he held that there was sufficient evidence on a balance of probabilities that Progresso had duly authorized the claim to be brought, had duly authorized Mr. Schneider to make the witness statement on his behalf, had duly authorized counsel to represent it in the claim, though none of these points had been raised before the hearing. And that was because the law requires that these points must be made before the defendant can be called upon to respond. My lords, it is a contention of the appellant that there is no evidence in the record of this case before the bar that Mr. Justice Abel made any of those findings. And it is a further contention of this appellant that the record disclosed no evidence upon which a learned trial judge could properly have made any of those findings. In the said case of VH and others, Lord Nichols wrote at page 19 as follows. The starting point here is that courts act on evidence. They reach their decision on the basis of the evidence before them. Evidence is a means whereby relevant facts are proved in court. What the evidence is required to establish depends upon the issue the court has to decide. So, my lordship, going back to the issue of the video link claim, if there was no evidence before the court that Schneider was authorized to make the affidavit, then the court could not have acted on behalf of Progresso in that regard, because there is no evidence of Progresso before the court.
Mr. Elrington,
yes,
I'm sorry to cut you in full flow, but could I just ask you this? There was a resolution apparently passed at an annual general meeting of the company on the 19th of November, 2015. What do you say about that? Because I suspect the argument on the other side is that that resolution authorized the commencement of the action against you by the company. Can you clarify that for us, please?
Yes, my lord, I'm happy to do that. My lord, in this case before Mr. Justice Abel, only one single person was called to give evidence. That was Lawrence Schneider. At no point during the time he gave evidence was any resolution mentioned nor introduced into evidence. My understanding is that a clerk from the Office of Courtney and Cowley had lodged minutes, or that minutes had been lodged in the court. None of that was ever tendered in evidence. No opportunity was offered to cross-examine on it for the courts to determine whether or not it was a proper resolution, if it was in fact a resolution. But the fundamental point I'm making, Your Lordship, is that if there was no claimant before the court, there could be no resolution supporting the claimant.
But the resolution. Sorry, my sister, please go ahead.
No, you go ahead, Judge.
Yes, well, I was just asking, sir, whether the resolution is not the instrument by which the claimant becomes the claimant. In other words, if the resolution is validly passed, does it not authorize the company to commence action and therefore be a claimant in the action?
It would, if validly passed, my lord, and if it is tendered as part of the evidence and accepted as evidence.
I understand that it was annexed to the affidavit by Carla Sebastian. Is that the case, the resolution I'm speaking of 19th November 2015?
Yes, my lord. And I
Yes.
never saw Carla Sebastian. She never appeared before court. She was never examined or cross-examined. But can I say, my lord, even more fundamental than that, is that if you don't have a claimant, you can't have witness evidence in support of the claim.
Mr. Elton, can I ask you, how did, if at all, how did the trial judge deal with that resolution and that affidavit of Carla Sebastian?
Only in his judgment.
Yes, that's what I mean. Yeah, just let me know where.
He just made mention that, in fact, that gave authority, but it was never part of the evidence at no time, because there was only one person. Carla Sebastian is a stranger to these proceedings, never took the witness stand. At no time. There was no tendering of that affidavit, of that resolution. There was no opportunity to challenge it. It was lodged in the registry, and that is where it remained.
So it was not served on you then, sir? I'm sorry.
At no time. It was lodged surreptitiously, I must say, because the first I heard of it was at the end, the very end of the submission in the case before Mr. Justice Abel, when the other side made reference to it. I never saw it. never knew it existed.
I don't want to quibble, Mr. Elrington, but maybe we shouldn't say surreptitiously, since we don't know when it was filed in the registry.
When and how. Yes.
Indeed. And since we don't know, then it might be unwise for us to use the word surreptitiously. But anyway, I'm sorry to interrupt you.
No, my lord. May I just continue?
Yeah, of course.
All right. Now, the appellant contends that there are no facts, no evidence in the record before your lordships indicating that the claimant was before the court or that Lawrence Schneider was its delegate or its embodiment. Counsel for Progresso sought to prove Progresso's claim by inviting Lawrence Schneider to testify on Progresso's behalf in the High Court. It is not being disputed that Lawrence Schneider is a director of Progresso and is major shareholder. He is also the author of the sole witness statement purportedly filed on behalf of Progresso in the court. Counsel relied exclusively upon Lawrence Schneider to judge Progresso's evidentiary burden before the court. But Lawrence Schneider is definitely not Progresso, neither in law nor in fact. It is respectfully submitted that Progresso and Lawrence Schneider are two completely and totally different legal entities, as different from each other as the sun is from the moon. Progresso is an artificial person. Lawrence Schneider is a natural person. And although Lawrence Schneider is a director of Progresso, in law he possesses no inherent power or authority by virtue of that office to act for and on behalf of Progresso or to present it in court. In a judgment in the case of Sal Industrial Leasing Limited against Hydro Mesh, Judith Prakash wrote as follows: by the general law, directors can act on behalf of the company at board meetings in which their collective decisions are assessed by resolution. They have no power to act individually as agents for the company. Based on that dictum, it is submitted that the ordinary director appears to be as powerless as the mere busybody in terms of the capacity, his capacity to participate in litigation by corporate entities.
Mr. Elrington.
Yes.
Sorry, just a quick question. You may not know. What was Mr. Snyder's shareholding in Progresso? How much did he? What was his shareholding?
He may have had maybe I had 20%, and he might have had 40 and 26, 40 or 60%. I'm not sure.
You said 40 or 60?
Yes, may have.
Yeah, if he has 60, that's very much different from if he had 40.
Yes, I understand that. But is there, my lord, it is not my understanding that the quantum of your shares gives you any authority.
Well, the geometric principle could come into play, but this is something principle could come into play if he had 60%.
In regard,
yeah, if he could ratify.
But even so, my lord, even so, there is no evidence of any of that, and it would only be
is there evidence? Is there evidence of a shareholding?
It did not come out in evidence.
Okay, thank you.
None of that came out in evidence.
Thank you.
The only person that took the witness stand was Lawrence Schneider, and all he said he was duly authorized. And when asked how he was authorized, he says by the memorandum and articles of association, and at the invitation of counsel for his counsel invited the court to disregard that response. So the only information that the court has before it is Lawrence Schneider's statement in the witness stand that he was duly authorized to make the witness statement. That's the totality of the evidence from Schneider before the court. Let me just proceed, sir. May I?
Was there any evidence, before you proceed, was there any evidence to suggest that he was not entitled?
So, not entitled to what, sir?
to bring the action, or that
All
the
right.
company was not
I'm
entitled
about-
to bring the action.
I'm about to deal with that.
I see. Okay.
First, I want to make it pellucid that at no time, it was suggested that the company was not competent to bring the action. That was never an issue. How the Court of Appeal arrived at that, I don't know. Even though I said it repeatedly, it baffled me how that conclusion was reached. Because the issue that I raised simply emanated from the response by Schneider that he was authorized by the Memorandum and Articles of Association. It was limited to him alone, not the company. I knew quite clearly that the company was fully authorized to bring the action. But I go on, Your Lords.
No, just before you go on, the memorandum and the articles would have detailed the quantum of his shareholding.
I would imagine that would be there.
Yes.
All right. Being an artificial person, it was impossible for Progresso to enter into the witness stand and deliver viva voce evidence to the court. And this is a case where the obligation was Progresso's to give the evidence. Such evidence can only be given by natural persons. In order to circumvent that hurdle, here in Belize, we have reduced to a rule of court the common law principle that companies can authorize directors by resolution to represent them in litigation. Our Supreme Court Civil Procedure Rules 2005 provide in Rule 22(g)(1) as follows. Subject to any statutory provision to the contrary, a duly authorized director or other officer of a body corporate may conduct proceedings on his behalf. And Rule 22(3) provides in paragraph 1 and 2, duly authorized means authorized by the body corporate to conduct the proceedings on its behalf by a resolution passed for that purpose. So there had to be a resolution based on that rule. It is therefore submitted that in order for Lawrence Schneider to have been able to discharge Progresso's evidentiary burden before the court, it was imperative for Progresso to have adduced evidence, for Progresso to have adduced evidence to the court showing that it had duly delegated its powers to Lawrence Schneider to conduct the proceedings on his behalf by a resolution passed for that purpose. But the record of appeal is completely bereft of any such resolution. In the judgment of the House of Lords, in the case of Meridian Global Funds Management Asia Limited against Securities Commission, Lord Huffman, and here, my Lord, I will read a little in extenso because of the nature of the extract. It says, having referred to it being a necessary part of a corporate personality, that there should be rules by which acts are attributed to the company, Lord Huffman went on to write as follows. The company's rules of attribution will generally be found in its constitution, typically the Articles of Association, and it will say such things as, for the purpose of appointing members of the board, a majority vote of the shareholders shall be a decision of the company, or the decisions of the board in managing the company's business shall be the decisions of the company. There are also primary rules of attribution, which are not expressly stated in the articles, but implied by company law, such as the unanimous decision of all the shareholders in a solvent company about anything which a company under its memorandum of association has power to do shall be the decision of the company. The primary rules of attribution are obviously not enough to enable a company to go out into the world and to do business. Not every act on behalf of the company could be expected to be the subject of a resolution of the board or unanimous decision of the shareholders. The company therefore builds upon the primary rules of attribution by using general rules of attribution, which are equally available to natural persons, namely the principle of agency. The company will appoint servants and agents whose acts by a combination of the general principle of agency and the company's principal primary rules of attribution count as the acts of the company. So the company has to formally act to appoint agents, formally, and that is done through resolutions. In the House of Lords case of Tesco Supermarkets Limited and Natras, At page 198, Lord Dicko wrote as follows: a corporation is an abstraction. It is incapable itself of doing any physical act or being in any state of mind. Yet in law, it is a person. He goes on to say, in my view, therefore, the question, what natural persons are to be treated in law as being a company for the purpose of acts done in the course of its business, is to be found by identifying those natural persons who, by the memorandum and articles of association, or as a result of action taken by the directors or by the company in general meeting, pursuant to the articles, are entrusted with the exercise of the powers of the company. So that the court has to say, in the presence of anybody who turns up as a witness for a corporation, by what means you purport to act as the corporation. You obviously are not the corporation. In the same case, Lord Reed wrote in his judgment at page 170 as follows: I must start by considering the nature of the personality which by a fiction the law attributes to a corporation. A living person has a mind which can have knowledge or intention to be negligent, and he has hands to carry out his intentions. A corporation has none of these. It must act through living persons. Then the person who acts is not speaking or acting for the company. He is acting as a company, and his mind which directs his acts is a mind of the company. On page 171, Lord Reed continues as follows: but the board of directors may delegate some part of their functions of management, giving to their delegate full discretion to act independently of instructions from them. I see no difficulty in holding that they have thereby put such a delegate in their place, so that within the scope of the delegation, he can act as the company. Lord Reed then stated at page 174, I have said that the board of directors can delegate part of their functions of management so as to make their delegate an embodiment of the company within the sphere of the delegation. But here the board never delegated any part of their function. In the said case, Lord Morris of Bortiges, on page 179, wrote in his judgment, how then does a company act? When is some act the act of a company as opposed to the act of a servant or agent of the company, which if done within the scope of the employment, the company will be civilly liable.
Mr. Elrington, sorry, I think
Yes.
we get the point. I think that we get the point. And further authorities will not help us. We fully understand the point you're making.
Yes, my lord. So the point, my lord, the point I'm making is that if in fact there was no delegation to Lawrence Schneider, if there in fact no resolution from the company, or in fact there is no extract from the articles indicating that Schneider had authority to act for the company, there is no company before the court.
You know, Mr. Elrington, sorry, President.
No, you go ahead. You go ahead.
Yeah, I just wanted to ask you this because I gather that there are some academic authorities that draw a distinction between closely held companies and companies where the shareholding is spread over a more impersonal class of persons. And the idea is that in relation to the closely held companies, a director, in the case of, for example, a company held by a father and son and one other person, that the father and son can, if they have, as in this case, apparently the majority shareholding, can take certain actions and expect that they are, ratified by agreement and so on. So that is one case in the closely held company, as opposed to more personal situation where you need the kind of resolution, that you were speaking about earlier. I just wanted to get your view on that. Is that a distinction that appeals to you at all?
My lord, I could see where that is a position, but my emphasis is that if that is the case, there must be evidence. because the court must act on evidence.
Sorry,
So
evidence.
if-
Sorry,
if
not
there
interrupted,
was-
but evidence of what precisely? In the case of a
Evidence
closely held company.
No, evidence that it was the thinking of the directors in a closely held company that this should be the case.
Oh, I see. Okay.
One cannot simply assume that it's a closely held company and therefore both parties think at idem. No. And the court can't go on that basis. As I adverted to earlier, the court is a court of evidence. But my lord,
Mr. Elrington,
what I found.
Mr. Elrington, the articles and memorandum of association, do we have them as part of the record? Were they produced in before the court?
The memorandum and articles of association were part of the witness statement of Lawrence Snyder.
Fine, so that they are part of the evidence.
No, my lord, that's what I'm saying. Because there is no evidence that Lawrence Snyder had authority to speak for the company.
No, we're going round and around. I tell you why we're going round and around. You said that Mr. Schneider said, my authority to evidence the company bringing the action, my being a witness, is the memorandum and articles of the company. Didn't you say something like that?
Yes. Yes, my lord.
And he produced the memorandum and articles as part of his evidence. But you said it was part of his witness statement. Isn't what is in the witness statement part of the evidence?
Mr. President, the witness statement was filed. The witness statement was filed and it was never gone into in any detail. In other words,
no, but just now. I was a trial judge at some point, and the way that I know trials are contested after the CPR is that you file a witness statement. On the day of the trial, you go into the box. Your lawyer asks you, did you file a witness statement? You say yes. Your lawyer says, do you want that witness statement to be part of the evidence, your evidence? You say yes. And then the lawyer says, I tender you for cross-examination. Isn't that what happened there?
Yes, Mr. President.
And therefore, the memorandum and articles of association are part of his evidence. The burden was now on you to challenge that evidence.
Mr. President, my understanding is that for him to say bluntly that I am authorized by the memorandum and articles of association is not proof. He has to assert and prove. That is the onus that is on the claimant to assert and prove. And in the absence of proof that he was in fact.
Mr. Elrington, can I interrupt you a little bit? Do the articles and memorandum have anything that speak to a director having authority to do what he claimed he had authority to do?
I do have an authority in my authorities.
No.
My lord, there is absolutely nothing like that.
So that even for argument purposes, even if the articles and memo are part of the evidence, is it then your submission that there is nothing in there that gives him the authority he claimed that he had by it?
You are 100% correct.
All right,
my lord. And that is strengthened before without him seeing it. That is strengthened by the request of Progresso's counsel to the judge to disregard that part of the evidence. And the judge in his judgment said, I disregard that. So that was not part of the evidence that the judge looked at all. He simply disregarded that, alleging that that was not pleaded or some such thing. So he disregarded that. That is specifically disregarded by him.
No, my understanding is that he that the judge was saying that you did not plead that the claimant, the company, was not authorized to bring the action. And therefore, the judge did not regard any dispute of that on that point to be relevant to the proceedings because no issue was taken. I come back to the example that I gave about a minor or a bankrupt or about a mentally ill patient. Somebody presents and you take it for granted that they are a claimant until and unless someone brings proof. You keep talking about proof, but it seems to me that it is for the defendant first to plead that you are not authorized to bring this action because A, B, C, D, E, and you're not authorized because, and you provide the evidence that would substantiate the lack of authority. But what I'm getting from you is that a claimant must, without anyone challenging them, provide the proof that they have the authority to bring the action.
Mr. President, in the ordinary course, dealing with a corporation, it is easy for a litigant to challenge the capacity of the corporation to bring the action because all one has to do is look at the memorandum and articles and see what is the capacity of the corporation. There is absolutely no way that one can challenge the capacity of a witness to speak on behalf of a corporation, especially because one does not have the knowledge of the inner workings of such a corporation. That information is kept peculiarly within the company. It's a very different case in the case of a minor. You know a minor has certain limitation. You know a bankrupt has certain limitation because a bankrupt is published. There's a publicization of the bankruptcy. But in the case of a witness, one never knows what authority a witness has for a corporation. And it is for that reason that the corporation has to establish that before the court.
And isn't it established, as the president was pointing out to you, isn't that established in the memorandum and articles? Isn't the governance of the company established in the memo and articles? I used to think so.
The memorandum and articles in this association confers no authority on Schneider or any individual director. As I will show you,
you're saying this as a matter of fact, having examined the articles and memorandum. Okay.
As a matter of fact, that is the case as a matter of fact.
Thank you.
I will cite authorities which bolster that position, if you permit me.
But you can't cite the authorities because the memorandum and articles are peculiar to the company. So I don't see how citing the authorities is going to help us.
At what pages? Where can we find the memo and articles? Where can we find that in the record?
No.
Your Honor, it's at page 2007 of the record.
Thank you.
May I proceed, Your Lordship?
Yes, you've actually run out of time, but we'll give you another 5 or 10 minutes at most.
All right. For my submissions. The main submission. 1 second, my lord, if I just find.
Yes.
My lord, I just want to quote from the All England Law Report. It is the Annual Review 1996, All England Law Report, Annual Review 1996. It says litigation in the company's name. Commencing litigation in the name of the company is a decision that can only be made by a duly authorized organ of the company, and at least where the position is not complicated by directors being among the alleged wrongdoers, it is for the board as a part of the management function to make such decisions, cites Breckland Group Holdings Limited against London. This principle was applied in Mitchell and Hobbs, where an action initiated by the managing director of a company, the company's name was struck out. The court rejected the argument that Article 70 of Table E authorized individual directors to commence corporate actions, and also the claim that as managing director, he was imbued with the authority so to act. The rejection of the argument that a managing director has by virtue of office powers over and above those enjoyed by the other directors is consistent with the other decisions of House of Lords in Harold Holdsworth, although the case was not cited. My lord, if I move forward to the case of Mitchell and Hobbs, which is very, very similar to the case, to this case here. It was, the judge was matching. It says, finally, the appellant submits the issues raised in this appeal are most similar to those raised in the case of Mitchell and Hobbs, United Kingdom against Mills. Anthony Machin, QC, sitting as deputy judge of the court, recounted, commencing on page 103, the facts and circumstances of this case. Because of their similarity with the instant case, one appeal a failure of kind indulgence to quote fairly extensively from this said judgment. I quote, this was a small private company, and at the material time, because it is now, I think, being wound up or at least in no longer trading, Mr. Pierce was with Mr. Radford, one of the two directors of this company. It's agreed that Mr. Radford was a managing director and Mr. Mill was a company secretary. Radford was not only the managing director, he was a major shareholder, owning 66 shares in the company, there being 100 shares issued. Mr. Mill held 17 and Mr. Pierce the remaining 17. It is quite plain from the affidavits that Mr. Radford on the one hand and Mr. Pierce and Mill on the other hand have fallen out, but I am not concerned in any way with the rights and wrongs of their dispute. What I am concerned with is whether the action was brought properly, in the sense that it was authorized on behalf of the company that it should be brought. What happened and what generated the action was admitted to Mr. Mill in December 1994, withdrew from the company's bank account the sum claimed that is £3,900 for the purpose, he says, in his defense, to protect the company from being dissipated by Mr. Radford in breach of his by duty due to the company's creditors. It is not an issue that the money has not in any way been tampered with, if I can put it that way. Mr. Mill, it has been placed in an account in the name of the company's accountants. There is still part of the company's assets, but withdrawn in the manner I have described. The purpose of the action, which has been motivated by Mr. Radford, was to regain possession with £3,900. Judge Martin then goes on to say, I follow the principles which are set out in the speech in the Privy Council, in the judgment in the Court of Appeal, and in the judgment of Harman J. in arriving at my decision in the present case. And I ask myself, what is the evidence which is presently before me as to authority in relation to the institution of these proceedings? The only affidavit I have on behalf of Mr. Radford is a formal affidavit sworn in support of rule of the Supreme Court summons, which he says, I am and have been at all times the managing director and major shareholder of the plaintiff company, and I'm authorized to make this affidavit on his behalf. The contents of this affidavit are within my knowledge. So the affidavit does not in any way touch upon the question which I have to decide, which is whether Mr. Radford had any authority to instruct solicitors or on behalf of the plaintiff company to issue the present proceedings. What I have to decide, and it is decisive of the summons, is whether Mr. Radford had the authority to instruct solicitors on behalf of the plaintiff to issue the writ. Judge Machin then went on to state on page 107 of his judgment as follows: there being no evidence of any resolution of the board of the plaintiff company to institute these proceedings, I ask myself, how it comes about that they can be validly instituted. Based on that, he struck it out. There was no evidence. This identical case was cited and argued before Mr. Justice Abel. And in his judgment, Mr. Justice Abel said that this particular case here was a case that was not in any way relevant, and this was a case that had no directors. The record is here. It's a case that had no directors and was not relevant. None of the case. I also cited the Jeffrey Shearsden case in which he says authority has to be done by resolution. He said it was of no relevance to the case. But that's a fundamental issue. Now, my lordship, in the case of John Shaw and Salford, Roche Bay, if I may just make reference to his judgment very quickly. One second, my lords. Let me just find the authority. John Shaw and Salford. John Shaw, I think it must be the last case.
You have to be in the wrapping up mode now, Mr. Elrington.
Yes, my lord. I am really on the wrapping up mode. And I just want to cite one authority which I think is relevant.
You could just give us the name of it and the relevant page number.
That's what I'm trying to find. I'm trying to find it among my documents here. John Shaw, Salford.
But if it's referenced in your written submissions, then you can rest assured that we will consider it.
Well, all right, I found the case. It's this case of John Shaw and Sons against Salford Limited. And it's, yeah, CV528. Yeah. This is the Lord. All right.
It is so referenced, President, in paragraph 26 of Mr. Elrington's submission. So I believe we have him.
Yes.
President, before Mr. Elrington leaves, Mr. Can I ask you, Article or Clause 41, powers and duty of directors. You've looked at that. Is it your? You don't have to go through it with me. Is it your position that that does not give the authority about which which is contested?
Yes, my lord. There's no authority given by that.
No, the way it says the management of the business of the company shall be vested in directors. That clause you say is not sufficient, right?
No, my lord, that's a standard procedure that is found in almost all.
Right. And that is not sufficient.
No, that's not sufficient. The authorities that I cited from the 1996 Arlington.
All right, no, it's okay. It's okay.
There has to be a delegation. There always has to be a delegation. But
all right, good. No. You don't need to go any further. I just wanted to bring it to your attention and have on the record your position. Thank you.
Yes, I just want to address the point that seemed to be troubling the learned president. The learned president in relation to the issue as to the burden of proof. This is the decision of Roche J, the last decision in the case of John Shaw Salford. He says in his judgment, he says, I agree with both the Lord Justices as to the result of the decided cases and particularly of the Daimler case and of the Russian Commercial Bank. He said the principles to be derived from them are that such an objection is to be taken, such a right to sue as is here taken should be taken not at the trial but by an interlocutory motion or summons. that if such procedure is not adopted, the court need not and ordinarily should not entertain such an objection at the trial as if it were a defense. Because it's not a defense. We are not taking it as a defense. It's just a means of declaring that there's no case to answer. But it's not the defense, not really the defense. To say if it were otherwise, then for reasons pointed out by Warrington J. in Richmond and Branson, the position of the court would be well-nigh intolerable. Nevertheless, as appears from the decision in the Daimler case, if want of capacity or authority to sue plainly appears at any stage, the court may then strike out this action. It was argued for the respondents that the application of the latter principle was limited to objections based upon want of capacity to sue, and did not extend to objections based upon want of authority to sue. I see no reason for such limitation of the powers of the court. And in my opinion, the argument is not well founded. When it clearly appears that there is want of authority to sue, for example, if an admission in that sense were made in the course of the hearing, the same result, in my opinion, ought to follow, and the action in question ought to be struck out. And this is what happened in this case.
All right, Mr. Elrington, I think we have your submissions. We've gone way over time, and we have to look at the time. So if I could sum up your submissions, you're saying that in this case, there is no cogent evidence that the company was authorized to bring the action. You're saying that the fact that the witness statement exhibited the articles and memorandum of association was not sufficient to establish that the company, through Mr. Scheider, was entitled to bring the action, and that therefore there was no evidence in the court that the company's action was validly, properly brought. Those are his submissions in summary. Am I correct?
I would agree with that. I phrase it this way: there was no evidence that the company was before the court.
Thank you. Very well, Mr. Elrington. Ms. Banner?
Yes, Your Honor. Yes, Mr. President?
Yes, please. We are ready to hear you.
Much obliged.
Ms. Banner, as you are starting, could I just ask you this? Is there anything that Mr. Elrington said in his submissions going on an hour and 15 minutes that would have caught you by surprise? Would have been an ambush?
Your Honor, the arguments being made by Mr. Elrington are arguments that we've heard repeated quite a few times. So there's nothing that catches us by surprise other than, of course, the first issue, which is the application to amend the notice of appeal.
Yes, but he was applying to amend it to say what he said. So if what he said didn't catch you by surprise, I'm just wondering, why did you object to the application?
Yes, we objected to the application, Your Honor, because when one reads the notice of appeal, if Your Honor would look through the notice of appeal, Your Honor will see that this was a dual appeal by Mr. Elrington, the appellant. Appeals from there's an appeal from the decision of the High Court of Mr. Justice Abel, but there's also an appeal which was abandoned with respect to the decision of the Court of Appeal. If the court would look at the notice of appeal, when one reviews that notice of appeal, it is clear here at the beginning, take notice that the appellant hereby appeals to the Caribbean Court of Justice against the judgment of the High Court of Justice. And then it speaks of the decision promulgated 28th of September 2022. And then again, when one looks at the text, that the whole of the judgment, etc., the Supreme Court of Belize is mentioned. And then when one looks at the G, H, and I of the notice of appeal, reference is made to the Court of Appeal Erdin holding that the question whether the claim was legitimately brought by PHL did not arise on the pleadings and therefore was not an issue. And then there's H and I. So it is clear that the design of this notice of appeal was to appeal both against the judgment of Mr. Justice Abel in the High Court and the decision of the Court of Appeal. What Mr. Elrington proceeded to do in his submissions was to maintain 2A, which is the sole ground of appeal. The decision is against the weight of the evidence, and to disregard all the other grounds of appeal. So the grounds of appeal relating to the appeal from the Court of Appeal, those have been abandoned. And this is critical, Your Honor, because the decision is against the weight of the evidence. Is an appeal from it can only be an appeal from the decision of the learned trial judge who made certain findings of fact. Those findings
which were upheld, I take it, by the Court of Appeal.
Yes, Your Honor, and that is critical because when one looks at this court's own
So
ruling,
why couldn't he be interpreted as saying that the decision by the Court of Appeal was against the weight of the evidence?
well, Your Honor, there's a difficulty with that, and that is as expressed by this court, that it is only in exceptional circumstances that the CCJ will review concurrent findings of fact by lower courts. If there are concurrent findings of fact by both the High Court and the Court of Appeal with respect to these issues, then Mr. Elrington is locked into that
Sure,
fact.
but that's a different battleground that we're on. As opposed to opposing the application, if you see what I mean.
Yes, quite understandable, Your Honor. The difficulty I have is that when one looks at Shillingford and Andrew, Mr. Elrington has not identified how the appellant falls within any of those exceptional circumstances. And so the appeal is flawed fatally. Because the only ground that is really there is that the decision is against the weight of the evidence. Everything else has been abandoned. So in our humble submission, this appeal is fatally flawed. It is an appeal against the decision of the learned trial judge. It is made clear that this was to be a dual appeal because there are references both to the High Court and the Court of Appeal. So this is not an error or a typographical error. It is a design to appeal against both of those courts' decisions, which we say this is not appropriate in circumstances.
I understand. Thank you. Thank you much, Ms. Banner. Thank you.
Much obliged, Your Honor. Your Honor, in just accepting that would address our submissions on the first point that we were given 10 minutes for, I will just, with the court's permission, move on to the other grounds.
Yes, by all means.
Much obliged, Your Honor. Your Honors, just to quickly address some of the questions that were raised by the court. One of the first relates to the affidavit of Carla Sebastian, which was filed in response to the affidavit, but the affidavit having been filed formed a part of the record of the proceedings. Under our civil procedure rules, Your Honors, any evidence used in proceedings, whether at an application or some other hearing, may be used at the trial of the matter. And that is pursuant to Rule 29.3 of the High Court rules. Rule 29.3 states that any evidence taken at the trial or other hearing of any proceedings may be used subsequently in those proceedings. Hence, when the claimant made submissions in the court below regarding the affidavit of Carla Sebastian and the fact that it exhibited the minutes of the meeting, which were duly recorded in the registry, those minutes were certified, and that is apparent on the document itself. So the argument was that those minutes were properly tendered in evidence and they could be used at trial, and they could also be used in our arguments before the Court of Appeal. Those minutes demonstrate very clearly that the company authorized
just a minute, Ms. Martin, so wait a minute. That rule is a permissive rule. What it basically, I think, means is that if you have other evidence in a matter, you may use it, but you have to make an application to you. If you've started a trial, then you have to take steps to say you want to use that evidence, and so on. It's not that you can just pluck at it at any point, right? So what I want to ask is, were any steps taken to tender that affidavit of Carla Sebastian? Did the judge avert to that affidavit of Carla Sebastian?
Your Honor, the rule 29.3 that we quoted, our interpretation of that rule is that once the evidence is on the record and it is used in other proceedings, meaning that we file that specifically in response to the evidence of Mr. Elrington, then our interpretation of that rule is that that affidavit may be used without the need to tender it in evidence. Mr. Elrington at the time did not apply to cross-examine, did not suggest that there was any dispute of fact.
Pause. You may use it, but you can't. But to use it, you must say you intend to use it to be fair to the other side, so they can say they want to cross-examine on it. You can't have it there, never say you want to use it at trial, and then after the trial reference it. That won't be fair. What you do is you have all this evidence. Sometimes it constitutes a previous inconsistent statement, and you say in the injunction proceedings, affidavits are filed. I'd like your leave to rely on them. You get leave of the court to rely on them, for example, for that purpose. Or something is done. You say there's an affidavit filed. I want to tender it. You get leave of the court to tender it. But you can't have evidence in interlocutory. I don't think you can. If there's an authority that says so under the CPR, I'll be happy to look at it. But it doesn't seem to me to be fair.
Yes, Your Honor. We are relying solely on 29.23. We are not
Which
relying...
you read. I understand.
Yes,
I have it before
that is
me.
what we're relying on.
But it says may. But what is the procedure that triggers its use in a trial?
Yes,
Because
Your Honor. I appreciate the distinction the court is making.
Suppose you have injunction proceedings and you have a slew of affidavits.
Yes, Your Honor.
And then you come to a trial and you file, let's say, 2 witness statements or whatever it is, correct?
Yes,
and
Your
the
Honor.
trial proceeds on the evidence that was tendered for the purposes of the trial. No reference is made in the trial to what was filed in the injunction proceedings. Can you then come in addresses and say that without, at some point in the trial, indicating that you want to use or bringing it to the attention of a witness so they have an opportunity to respond?
Yes, Your Honor, I do understand the distinction the court is making. I can only put it as high as we indicated to counsel in handing the affidavit to him that it was an affidavit in response to his evidence, which we intended to rely on. And also
but did you tell the court that? What you tell counsel is not binding, you know. It's what is on the record. What did you do with the court? Did you tell the court that you intend to use this evidence? Was it tendered?
Yes, Your Honor, we did indicate this to the court, Your Honor. Oftentimes, some information is not reflected on the record because there's a chambers hearing for housekeeping matters before you actually go into trial. So unfortunately, I cannot give evidence to the court because there's no record of that here. But what I'm certain of is that it was made absolutely clear that the affidavit had been filed and we would be relying on it. In light of this very surprise ambush allegation made by Mr. Elrington that Mr. Schneider was not an authorized person and could not depose to any of the facts.
So you said you'd be relying on it. You said that to the court?
Your Honor, there is no record of
No, I know that. I know you told me there's no record, but I'm asking you.
To the court.
You said it to the court, and you said it to the court during the trial?
No, Your Honor. This affidavit was tendered in evidence during the video link proceedings. So this was well before the trial in July of 2019.
All right. Okay.
So this was an interlocutory application, and then later the trial came along. We considered, based on our then interpretation of the rules, and we're guided by the court, but our then interpretation of the rules is that the affidavit having been tendered into evidence because the minutes of the meeting were certified, and the rules as to evidence relating to a certified document is quite different. there is a rule relating to certified documents that once it's certified is deemed to be the record of what actually took place. This was a registered document in the registry.
Ms. Banner, did the trial judge rely on those certified minutes?
Your Honor, we see no reference in the judgment of the substantive judgment before the court referencing the affidavit of Carla Sebastian. It was referenced in the Court of Appeal judgment, but I do not see any reference to by the learned trial judge. What we can say, Your Honors, is that absolutely this was not a clandestine filing in the court. Counsel was
before you go on to that, before you go on, because you made the point that you handed it to Mr. Elrington, I take it, but I wanted to ask you about what does the Court of Appeal say about the minutes and the resolution and so on?
Yes, Your Honor, the Court of Appeal did reference the resolution, and I think confirmed that there is a resolution of the company, minutes of the company that demonstrate clearly that Progresso Heights Ltd had authorized the commencement of the claim.
Yeah, just show us where that is, please, Ms. Banner.
Yes, Your Honor. It will be on the very last, I believe it may have been something said by Madam Justice Minor Phillips during argument, or it would be in the last page of the second to last page of the judgment. If the court just gives me.
Sure, you go ahead.
Much obliged. Yes, what I'm seeing, Your Honor, is that this may have been during discussions with Madam Justice Minot Phillips, but the affidavit does not seem to have been referenced by Madam Justice Minot Phillips at page 15 of the record. That is where the question, which I think is a critical question, or I would submit as a critical question, which is that the appellant hearing had not pleaded this in his defense, and in fact had not applied for a stay of execution or strikeout, had not raised this issue. And I think that is the critical issue. But it appears that it wasn't mentioned here, but it was in fact used by us in argument, and it was discussed before the court.
Yeah, Ms. Mann, it appears that both the trial judge and the Court of Appeal relied on the pleading point, if I may call it that, to say that the appellant was wrong and could not go any further with that. But Mr. Elrington explained today the context of that, which is that he would not have known anything about a resolution or minutes because he is, I don't want to say estranged, but he's not part and parcel of the running of the company now. So I take it that he was saying that after pleadings were closed, I'm not sure if that is how he put it, but that is when he found out. So explain then to me what you think fairness would have dictated. Is it that because he did not plead it, he should be shut out?
Absolutely.
I'm sure you've considered this because you were in the Court of Appeal and so on.
Yes, Your Honor, absolutely. We say that very as strongly as we can. Pleading is very important, as this court has in fact.
What I'm saying to you is that he is saying that at that stage, he could not have known. So how then is a pleading point to shut you out?
Yes, Your Honor, I think what Mr. Elrington is saying is two things. And in the first is that at the point where pleadings were closed, he could not take the point that Mr. Schneider was not authorized. That's a separate issue, Your Honor. The other issue, which is an issue that he has raised before this court also, is that the claim itself was not an authorized claim, or sorry, the company did not commence the claim. And that is a pleading issue. And fairness dictated that that issue was raised by Mr. Elrington at the pleading stage, so that all this evidence, which extends far beyond that minutes that Carla Sebastian attached her affidavit, so that that issue could be properly ventilated by the claimant being permitted to properly advance evidence. In fact, the issue that is now before the court regarding the company not being authorized to commence the claim was not raised until trial. And if the court would look at the submission, the submissions going back and forth from pages 2334 to 2344 of the record, the court will see where I myself said very clearly at 2341, Ms. Banner, and then fourth, my lord, the claimant is properly represented by counsel in these proceedings which have commenced this claim. Mr. Elrington, as the defendant, has not challenged the commencement of the claim by Progresso. What Mr. Elrington is seeking to do is to strip the claimant of its witness. That was Mr. Elrington's sole intent on the interlocutory application. So we flagged to the court that this is not an issue of Mr. Elrington saying that the claimant is not properly before the court because the claimant did not commence this claim. So even at that point, Mr. Elrington could have made an application when we flagged this issue. Fairness dictated that he either put it in his pleaded case, or when we made the point very clearly to the court that this is not an issue of the claimant having properly commenced, he ought to have made an application at that point for the court to stay the proceedings and for the claimant to demonstrate very clearly that the claimant commenced the claim. And fairness dictates this, and Mr. Justice Jamadar had in fact referenced this fact in a previous case. Pleadings are important, as referenced by Mr. Justice Barrow in the case of Todd. And pleadings are important because it allows the parties to see what case they need to meet that case and to provide the relevant evidence that is necessary to answer any allegations that may be made. So it was wholly unfair for the defendant to take this ambush approach, which has already been deprecated by this court in other proceedings, to take that ambush approach to come at the trial, not even to make submissions, to cross-examine on the point as to whether the claim had been properly commenced, and then to make submissions. We made objections, the claimant made objections to the line of cross-examination as being irrelevant. And it is at that trial stage that this issue was raised and then submissions made. So we wholly take the view that fairness was not, fairness is important, yes, but the claimants were not treated fairly. The claimant was not treated fairly. It wasn't a case of the defendant not being treated fairly in this case. And even more important, Your Honors, when one looks at the record for the Court of Appeal, Mr. Elrington has vacillated in his positions regarding these issues. So it's very difficult to know exactly what case he's coming with. If one looks at page 4106 of the record, which is the transcript at the Court of Appeal, Mr. Elrington stated at page 4106, he said, Mr. Elrington, yes, Madam President. Yes, you can proceed now with your reply. Thank you very much. Could I start off by making it pellucid? Yes, pellucid. And I had at no time questioned the legitimacy of the company to make the claim. That is a misconception of the submission I am making. Madam President Hafiz Bertram, the question to the witness and then Mr. Elrington, only the company can bring a claim where it has suffered damage. So I'm not questioning the company's authority. I did not and will not do that. I'm not seeking to impugn the authority of the company at all. I want to make that pellucid. Okay, we got that. I also want to make it pellucid that I did not challenge the authority of Mr. Schneider to make the witness statement. I did not. In other words, I could have appealed the interim decision by Mr. Justice Abel with respect to the vigiling. I chose not to do that deliberately. And I did not take any position with respect to Lawrence Schneider when he made his witness statement. I could have not have done that because, as I intimated already, all the information was peculiarly with them. They had that knowledge I didn't have. So what is even more telling, Your Honors, is that the appellant decided deliberately not to appeal the interlocutory decision of Mr. Justice Abel. So the court is here considering a question that had been decided, the order perfected, and the 21 days for appeal having lapsed. The court is here considering that issue, even though that issue is now a nullity. It is not properly before this court, and the court, in my humble estimation, would not have the jurisdiction to determine that issue. Mr. Elrington himself stated he did not challenge the witness statement. So the issue as to whether Mr. Schneider was authorized to execute the affidavit is, in my humble submission, a dead issue. So that is one issue. And then the second issue deals with the commencement of the claim. Mr. Elrington himself stated on the record that he was not impugning the authority of the company. And that issue was the ambush issue, which was raised for the first time at the trial of the matter. So in our humble submission, Your Honors, the appellant has brought issues before the court that he ought to have brought by seeking leave to appeal on the affidavit issue. And then he's brought an ambush issue to the court, but he has no evidence to support that the company was not authorized or that Mr. Schneider was not authorized to sign that witness statement. And the court asked Mr. Elrington this question very pointedly. Is there evidence that he was not so authorized to execute this affidavit? And we made this argument in the court below. It's at 2337 of the record. Pardon me, my lord. Mr. Elrington, the defendant, has not provided to this court any evidence whatsoever, any evidence to rebut the witness's evidence that he's authorized to make this affidavit in these proceedings. And he clearly makes it in support of the claimant's application. So not only does he not have standing, but is a baseless allegation thrown out that has absolutely no flesh. It's totally incredible. And there's no evidence to support that Mr. Schneider isn't authorized. So that is the other point, my lord. There's no rebuttal affidavit signed by any other director of the claimant on behalf of Mr. Elrington for Mr. Elrington. There is nothing. So there was no evidence. Mr. Elrington, say for instance, did not find a shareholder or a director to provide evidence to rebut the fact that the majority shareholder was authorized and the director was authorized to execute this affidavit. Even more critically, the court asked this question as to whether as to the shareholding of the company. Mr. Elrington accepted during the course of arguments, he accepted that Mr. Schneider was the majority shareholder of the company, that he held 20% of the shares, and that Mr. Schneider and his son Adam Schneider were together held 80%, but that Mr. Schneider himself, and if I may reference the court to those pages, it's page 2339 of the record. Sorry, page 2338.
You mean the shareholding?
Yes, Your Honor. This relates to the shareholding.
Yes.
And if the court would review these pages from page 2337, where we make the argument, where we were arguing this before the court. We say, yes, my lord, I believe it is also admitted at 2339, but there is no issue as to that point, my lord. And we were saying there's no issue as to the majority shareholding of the company. And then we said, Mr. Schneider owns 55% of the shares, his son owns 25%, and the defendant, Mr. Elrington, owns 20%. And Yes, Your Honor, there is also much obliged for the indication there, which shows the share subscription. But here, Mr. Elrington says, the statement, I know it is not in the application, we're contesting none of that. And then the court says, all right, that's one of the questions I wanted to ask. And so Mr. Elrington continuously repeats, we are contesting none of that in terms of the majority shareholding. And the court has indicated the shareholding, which we are grateful for. It is there in the evidence that that Mr. Schneider was a majority shareholder and along with his son owned 80% of the shares. We also make reference, the court actually made a reference to that majority ownership at 2430 of the ruling in the transcript of the High Court.
I'm trying to understand the significance of the point you're making about the majority shareholding. Can you help me a little bit more? Is it related to the concept of the closed company I was raising with Mr. Elrington?
Yes, Your Honor. The court had also asked a question as to what was the shareholding, and I was just trying to assist with reference to those
okay.
the evidence relevant to that.
Thank you.
But the signatories to the minutes of the meeting were both Adam Schneider and Lawrence Schneider, the two sole directors and the majority shareholders. But just to make the point, Your Honor, is that there was no evidence from the appellant in the High Court, which even suggested or made any impact on the position that the claimant commenced the claim and that its director was in fact authorized to execute that affidavit.
I hear you very clearly. I suspect my colleagues do as well. Just to ask you this though, wouldn't it have made life in retrospect, hindsight 2020, so much easier if you had in the statement that you indicated you made about the commencement of the action by the company, simply alluded at that point to the affidavit of Carlos Sebastian and the resolution attached to that affidavit as indicative of the competence which had been granted to the claimant to start the action, or in hindsight, you don't think that would have been particularly useful? What say you?
Well, Your Honor, in our estimation, we had always taken the position as a claimant in the High Court that what was happening was another ambush approach by Mr. Elrington. It was a point that was not pleaded, and he had filed no application for stay of proceedings, no application for strikeout, and he had not raised the issue in his pretrial memorandum. In fact, he had not filed a pretrial memorandum. So the primary position of the claimant in the High Court is that this was an ambush.
Ms. Bala, can I just pause? The July affidavit would have been before that opportunity to file the pretrial objections and so. You remember the Sebastian affidavit you said comes in July, right? I'm just trying to get some sequence in. So in July, the affidavit comes, correct?
Yes, Your Honor.
Right. Is it that after that, the pretrial opportunity arose?
Yes, Your Honor. The pretrial, let me just find the pretrial.
You see, Mr. Elrington's point is he was surprised, right? You say he takes you by ambush. He says he's surprised. So I'm just trying to get a sequence.
Yes, Your Honor.
When did he know? Sorry, go on.
Yes, Your Honor. The pretrial memorandum is at the record at page 2089, but that is only the pretrial memorandum of the claimant.
No, what I'm asking is, you filed an affidavit of Sebastian in response to an affidavit an application he makes. That's in July, correct?
Yes, Your Honor.
All right. In that application, you disclose on the record through Carlos Sebastian the minutes and the resolution. So Mr. Elrington knows that. He knows that the minutes and the resolution, he sees that because that's a contested or an application in which you all exchanged affidavits, correct?
Yes, Your Honor.
All right. After that event, is it that the opportunity to file pre-trial objections or so on, is it that that occurs after that event, or did it happen before that event?
Well, Your Honor, I don't believe that there was. Normally, there is a rule that provides that you may make certain objections and give notice, but I don't recall that that is something that the parties considered at the time in terms of objections.
How
And
long before the trial was this affidavit of Carlos Sebastian?
so the affidavit of Carlos Sebastian was the 10th of April. Let me see. Pardon me, Your Honor. 18. So that affidavit is dated the 10th of April 2019, and the trial
I see
The-
the hearing dates according to Mr. Justice Abel was from the 18th of March 2019, running
Yes.
many days, and the 10th of April being one.
Yes, Your Honor, but the trial did not start then. It was just a lot of different hearings. So the trial started long after, but the trial date, if I may just, if the court may just give me a moment, would be on the transcript. Transcript.
I didn't intend to interrupt what our brother was asking. I just wanted to get some chronology in to bring some clarity to what he was trying to get at. Justice Anderson, I apologize if I have taken.
No need, my brother. That's fine.
I just was hoping to get a little chronology in to understand what the response to you was going to be a little better from my point of view.
Yes, Your Honor. I understand.
Is it the 12th of July, 2019?
Your Honor, what I see here, pardon me. Your Honor, what I see here, and this is probably the reason why I've been having a lot of trouble with the record because of the way it's prepared, but I'm not even seeing the transcript from the substantive hearing. And I think that is why the issues as to the questions being asked by Mr. Justice Jamadar regarding the statement in court that there's an affidavit of Carlos Sebastian. I recall that that was referenced, but I'm not seeing the transcript of the substantive hearing. And I think that's where the court might find those references to Carlos Sebastian.
I don't want to find the references right now. I just want to know chronology. When we know that you filed the affidavit on the 10th of April 2019, correct?
Yes.
When did the hearing before Justice Abel begin?
Yes, Your Honor. Quite, I understand the court. I will find that.
All right, maybe you can give it to us later. Let's not delay. You can find it and give it to us later. It was after that, right?
Your Honor, my recollection is the trial happened long after that.
Okay, good. Right.
It was quite a time after. It wasn't immediately after. But perhaps I can look at the issue very quickly. I just need to reprint the judgment because it's really filed all over the place, and I tried to keep the numberings. But I can certainly find that page for the court and get it to the court. But my recollection is that it was held long after the application for evidence to be taken by VigilLink.
Okay, thank you.
Yes, Your Honor. Yes, Your Honor. So going back to the argument, I just wanted to reference the articles for the court, but we had already done so. I believe Article 41 is the relevant article dealing with the duties and powers of directors. So I just wanted to reference that because I appreciate that the court had asked a question. So just to summarize the arguments that we are making to the court. First, this is an appeal from both the High Court decision and the Court of Appeal. We've made that argument already.
Ms. Banner, sorry. You just said you want to reference Article 41, but I asked Mr. Elrington, did Article 41 give the power to a director to commence litigation? He said unequivocally no. What's your position?
Yes, our position is that if this issue had not been an ambush on the claimant would have tendered the same affidavit, or we consider it as being tendered, but I appreciate that the court might not take that position. But the applicant would have tendered the very same minutes attached to the affidavit of Carla Sebastian to clearly demonstrate that the claimant had authorized the claim. But the fact is
I'm understanding that. I'm asking you something different. Does Article 41, standing on its own, authorize, forget the resolution for now?
Yes, Your Honor.
You just said that you wanted to bring to our attention Article 41. But what are you saying about Article 41?
Your Honor, I was just assisting the court because the court had asked Mr. Elrington a question.
Okay.
As to whether or not there were, whether the directors had any powers or duties and conferred by the articles. And I believe Mr. Elrington made the point that no, there was no conferral of any power on the directors. But I wish to make the point to the court that the articles do confer power and duties on the directors, and that is why I referenced the article.
That's it said Article 41.
Yes, Your Honor. Yes, Mr. President.
So you wouldn't give a straight answer to Justice Jamala's question, which is, let me go again, that are you saying that Article 41 confers power on Mr. Schneider to have brought this action in the name of the company?
No, Your Honor, we did not rely on Article 41 for anything. I was simply trying to assist the court because a question was put as to whether the directors had any powers to do anything. I don't think it was specific to bringing of a claim. And I referenced this article to show that Mr. Elrington, having said he reviewed the articles and didn't see that the directors had any powers, misrepresented the articles because there are powers and duties imposed on directors in the articles. So we did not rely on Article 41. Our primary position is that this was an ambush by the defendant at the trial of the matter. It was not pleaded. There was no application for strikeout or stay. It was not an issue in the memorandum. It is not appropriately before this court in our humble submission. Our position in any event is that there was sufficient evidence in the court below to find that this claim was authorized. And looking at the totality of the evidence, where there is the admitted majority shareholding of the directors, the fact of the minutes of the meeting by Carla Sebastian, the fact that Adam Schneider and Mr. Schneider, they're both the sole directors of the company, and the fact that there's a resounding absence of evidence by the appellant to suggest otherwise, to suggest that this claim was not so authorized by the company. In our humble submission, Your Honors, it is not sufficient for one to throw out a statement that this claim is not authorized without providing any positive evidence in support of that contention. No evidence was presented to suggest that there may have been a dispute between directors or shareholders, or there was a quarrel and this claim wasn't authorized and the company is acting without authority. Nothing of that sort was presented. So there's no evidence to support that contention that was made. In our humble submission, the learned trial judge was right to find that the case was not made out. Those facts have not been overturned. There are concurrent findings of fact, and in our humble opinion or submission, the appellant falls within none of the exceptions that are identified in Shillingford to suggest that an exceptional circumstance exists, that this court would look behind those facts of the learned trial judge and overturn the learned trial judge's findings of fact. So there, in the totality of the evidence, the test that has been identified for overturning findings of fact, that test also has not been met. Even if one were to say, okay, fine, let's put aside the concurrent findings of fact jurisdiction established by this court, principle established by this court. The question that would arise then, which we say Mr. Elrington has not met, that question is the appellate's court review of trial judge's findings of fact on the basis that the judge made a decision no reasonable judge could have reached. So the appellant commences his submissions by relying on Brace, Girdle, and Oxley, in which Mr. Justice Denning said the court will only interfere if the conclusion cannot reasonably be drawn from the primary facts. But that is the case here, in my opinion. The conclusion drawn by these justices from the primary facts was not one that could reasonably be drawn from them. In applying Brace Girdle, even on the appellant's own case, he has not satisfied the test. So the question that the court may want to ask is, okay, what are the primary facts, right? If you look at the primary facts, and this is subject to our contention that the issue of authority does not arise on the pleadings, but the primary facts, Lawrence Schneider and Adam Schneider were the only two directors of Progresso. Lawrence Schneider and Adam Schneider were the shareholders of Progresso, majority owning 80% of the shares. Lawrence Schneider stated in his witness statement that he was duly authorized to give the witness statement on behalf of Progresso at trial. The affidavit of Carla Sebastian has recorded minutes that have been registered, and based on the Evidence Act would be deemed to be a true record of what appears at the registry. Lawrence Schneider himself testified in cross-examination in any event that he is authorized by the Articles of Association and resolutions passed by Progresso to engage CCLP to act for it within the proceedings. Based on the primary facts.
Just hold on, Ms. Banner. Did he say he was authorized by the articles and resolution? Because you just added that. Did he say that in cross-examination?
Your Honor, I don't believe the court has the record of the cross-examination before it because it was excluded from the record, but we would be happy to present that transcript to the court once it's available.
All right, I just want to be clear. Mr. Elrington asked him a question in cross-examination, and in answer in cross-examination, he said his authority was based on the articles and a resolution. I'm very interested in the and a resolution.
Yes, Your Honor. Your Honor, may I have, I don't want to speak out of turn. May I have 5 minutes to look into this issue for the court once I'm finished with my presentation, and then I can report to the court? Because my recollection is that the witness, and to be quite fair to the witness, Your Honor, Mr. Elrington is asking a question as an attorney, and this witness is a layperson answering this question. And this is why it's so important and why the appellate courts give deference to the trial judges, because they're able to see the witnesses on the stand and to see how they are responding to these things.
Ms. Banner, we are very aware of all of that. You know, we're just trying to get to some facts that can help us.
Yes, Your Honor.
So it would help us because up to now, my understanding, and I accept that it may have been a little defective, was that what he was saying is that his authority was vested on the articles and memo. You have just added that in cross-examination, he said in answer to Mr. Elrington that his authority to bring the action was on the basis of the articles and a resolution.
Yes,
so that's what I'm interested. You don't have to find it and send it in due course.
Much obliged, Your Honor. I believe what occurred is that he did not say the Carla Sebastian affidavit, but he said resolutions. So that's my recollection of the evidence, but please have me just stick a pin there because I don't want to not guide the court properly. So I will look for the reference and send it to the court. But that is distinctly my recollection, because it wasn't just this that he said. This line of questioning went on for quite a while.
But you see, Ms. Manna, evidence elicited in cross-examination is to be read, quote unquote, against the cross-examiner. So if you ask a question in cross-examination, you get an answer. Well, by resolution, it may be that that is the prima facie proof. It is then for the person who's cross-examining to produce evidence to the contrary. That is the adversarial system as I understand it. So that up to now, if we were looking in the articles and the memo, looking at 41, we have the Carla Sebastian affidavit floating around somewhere as part of the court proceedings. Now you say in the trial, he, apart from what is on his witness statement in paragraph 1, he answers and says, hold on, my authority is by resolution.
No, I don't think it is that, Your Honor. I think it was a chain of cross-examination.
Whatever it is, if he refers to an authority vested on the basis of company resolutions, that's what we want to see.
Yes, Your Honor, we will definitely source that transcript so that we can present it to the court. I do appreciate the court's guidance. Unfortunately, it came to my notice last minute that the record that the appellant had prepared did not include all the documents that we needed. But Your Honors, I will source that information and provide it to the court as urgently as possible. But based on the primary facts that were presented to the court, the learned trial judge found several things, Your Honors. The learned trial judge found that he was satisfied that Lawrence Schneider had and has actual and ostensible authority as Progresso's director to testify on behalf of Progresso. That's at paragraph 183 of the High Court judgment at page 3778 of the record. He found as a matter of fact that Progresso was a proper party before the court, which is the very same reference. He stated that no application was made by Mr. Elrington to strike out Progresso from the proceedings, and as such it remained a party, or to strike out the claim for lack of jurisdiction, or for an order that Progresso is not a proper party to bring the present claim for removal of cautions. And then he stated that Progresso is to be considered as properly a party to the present consolidated claims and therefore properly before this court. And then the court stood by its earlier decision made in the Vigilink hearing, where he said the question of authorization was raised by Mr. Elrington, and the court ruled that in the circumstances of the present case, authorization of a corporate body need not be given by way of resolution of a company for its director to swear an affidavit on its behalf. So, and then as a matter of pleading point at 187 of the same, sorry, that was 188. So I am reading from 183 to 189. That was 188, that reference. And then at 187, the court says, as a matter of pleading point, the court should, and this is the quotation, the court should disregard the evidence relating to authorization, which was elicited by cross-examination, as such evidence was not properly in issue from the proceedings. So what we humbly submit to the court is that in accordance with Brace Girdle, which is a decision relied on by Mr. Elrington himself, there was evidence on which a learned trial judge could come to the conclusions of fact at which he arrived. And even taking into account the dicta of Brace Girdle, this court will not interfere with a trial judge's findings of fact in circumstances in which the conclusions can reasonably be drawn from the primary facts. And so we humbly submit that the learned trial judge was right to make the conclusions that it made based on the primary facts established at trial. And moving on to the point regarding litigation by corporate bodies that my learned friend raised, my learned friend prayed in aid Rule 23.31 of the High Court Civil Procedure Rules, which reads, subject to any statutory provision to the contrary, a duly authorized director or other officer of a body corporate may conduct proceedings on its behalf. And then it says a body corporate must be represented by a legal practitioner in any hearing in open court unless the court permits it to be represented by a duly authorized director or other officer. And so what he is suggesting is that Rule 23.31 contains specific provisions governing the conduct of litigation by a corporate body. However, that rule, Your Honors, has no applicability to the case at bar. And you can see why I say that, because what the appellant did was to rely on Jeffrey Sursland and St. Matthew's University. And the point of his argument appears to be that Lawrence Schneider could not conduct litigation on behalf of Progresso since no resolution of Progresso was tendered into evidence, authorizing Schneider to prepare and file a witness statement, an affidavit, and to give evidence in the proceedings. So he makes the argument that there was not before the court any evidence of the respondent in the absence of such resolution, and as such the entire claim falls away. But what the appellant has failed to make clear to this honorable court is that Lawrence Schneider did not conduct proceedings on behalf of Progresso within the meaning of Rule 22.31, and that Sursland, the case that my learned friend relied on, is wholly inapplicable to the case at bar and is wholly distinguishable. Just to let the court know, Sursland is not a case like the case at bar. In the case at bar, Progresso Heights Ltd, the company itself, filed a claim, commenced proceedings. In Jeffrey Sursland and St. Matthew's University, the shareholders of the company commenced proceedings in their own name against the company and did not get any leave of the court. So my learned friend is relying on 23.31 and Sursland to make the point that what Sursland's ultimate holding is that the claimants could not commence proceedings on behalf of the company. It was a derivative claim. They could not do so without getting leave of the court. Sursland concerned the institution of proceedings by shareholders of a company in their own names as claimants for wrongs that were done to the company. In our case, the claimant is the company and the wrongs were done to it, and it has commenced proceedings. So in Sursland, none of the claimants had obtained permission from the trial court to commence a claim with respect to wrongs done to the company, St. Matthew's University. And we are all aware, Your Honor, that it's an established corporate principle of company law that the company must bring such an action except where the court approves a derivative action. And the action commenced by the shareholders had been commenced in Sursland had been commenced without the authority of the company, and as such, the shareholders' action could not proceed. So, Your Honors, and there is an authority relied on by my learned friend, which makes the point, which is the Meridian Global Funds Management Asia Limited and the Securities Commission's 1995 UK PC Privy Council decision dated 26th of June 1995. And the very authority relied on by the appellant for these tried principles of law suggests that because what my learned friend had done was to argue that as a legal person, a company must act through others and its decisions are expressed by resolutions. Further, that directors have no power to act individually or as agents for the company, and directors have no inherent power or authority by virtue of his office to act for or on behalf of a corporate body. And so what the authority relied on said at paragraph 9 of Meridian, not every act on behalf of the company could be expected to be the subject of a resolution of the board or a unanimous decision of the shareholders. The company therefore builds upon the primary rules of attribution by using general rules of attribution, which are equally available to natural persons, namely the principles of agency. And this is very important, Your Honors, because there is no provision, to my humble recollection, in the articles which says that in order for the company to commence a claim, it must be done in such and such a way. So when one looks at the totality of the evidence as the learned trial judge did, it is clear that the learned trial judge had sufficient primary facts that he could rely on to make the conclusions that he did, which is that this claim, Mr. Schneider, one, could execute an affidavit on behalf of the company, and two, that this claim was properly authorized by the company. And in our humble submission, that finding still stands. those findings of fact having not been overturned. So, Your Honors, to just summarize the points that we made, in our humble estimation, there are numerous hurdles that the appellant must cross in order to even begin to argue this ground. In our estimation, the appeal is fatally flawed, not only because the appeal seeks to be an appeal from the High Court. On the material, the only ground being relied on, it's an appeal from the High Court, not from the Court of Appeal, all the other grounds having been abandoned. Not only because there's a pleading hurdle, the appellant did not plead this in his defense. There's a procedural hurdle. The applicant did not file an application for stay to allow the claimant to prove that it had authorized the claim, which it was at liberty to do. It did not file an application for strikeout on the basis that the claimant was not authorized to file a claim. It did not give notice or raise notice of the issue that it would seek to assert that the claim was not properly authorized. So there are those pleading hurdles. There's the interlocutory application hurdle, which is that this matter was determined already long before the trial. The order was perfected more than 21 days before the trial, long before the trial. And the fact is that it was not appealed. And the reason it was not appealed is because from the appellant's own evidence, it was deliberately decided that he would not file an appeal. In our humble estimation, there is no jurisdictional basis in our humble estimation to consider this issue because there was no appeal filed as to the authorization issue. We also say in summary that the tests for overturning findings of fact have not been met. There was a factual basis for the learned trial judge to make the findings that he did, and he properly made those findings which were not overturned on appeal, which leads us to the point that there are concurrent findings of fact, which the court will only interfere with in exceptional circumstances. And and we would like to put a point on this court's own decision regarding how pleadings are to be treated. Yes, we understand that issues may arise in the course of proceedings. There's no gainsaying that. But from both a procedural and a substantive standpoint, the appellant failed to address these issues as they ought to have been addressed in order to allow fairness to the respondent. In the circumstances, Your Honors, we would humbly submit that the appeal should be dismissed with costs to the respondent in this court and in the courts below. And those are our submissions, unless the court has any questions for us.
No, apparently. So thank you very much, Ms. Banner. Mr. Elrington, you have, what, 10 minutes?
Much
Thank
obliged.
you.
You don't have to feel obliged to take all 10 minutes if you...
Mr. President, I thank you. I can't see you. Something is going wrong with my computer. I trust you can.
Oh, I see. We are seeing and hearing you very well.
All right, excellent. First of all, Mr. President, let me say that the issue of authority was an issue raised by the other side, not us. It was an issue relied upon by the other side in their pleadings. So it could not have been ambushed by us. The question which we asked under cross-examination was a question which we were obliged to ask under consideration to test the credibility of the witness. And the witness response is pellucid, and it is to be found in the record of the appeal, which is properly filed, and I have it at page 428 of 805. It's in my submissions, original submissions to your lordships, and it's on page, for the record, we have it as page 3975 of 3981. That is right there. And it says it's pellucid. Lawrence Snyder replied, I can provide the memorandum and articles of association that you yourself prepared, Mr. Elrington, July 21st, 2003, making me or placing me as a director of Progresso Heights Ltd. That document gave me authority to make decisions on behalf of the company. That is the totality of the evidence that is before the court. The court has to make its decision based on evidence, and that is the totality. But no sooner had he said that, in the judgment, in the submission to the learned trial judge, counsel for the respondent asked that that particular response be excluded because it was not pleaded. Well, it was not my business to plead it. It was pleaded by them, and I had an obligation to respond to it.
But Mr. Elrington, what you're reading from the original document, then the transcript of the proceedings before Mr. Justice Abel, that is not before us.
I got it out of the documentation that was submitted to the CCJ.
No, what I'm asking is the transcript of the proceedings before Mr. Justice Abel before us, or is that what Ms. Banner was saying she would look at and attempt again?
It should be before you. It should be before you. I think that's where I got it from. I have page 428 of 805 of the record of appeal.
Does it have a CCJ page number?
Page 3975 of 3981, 2023-08-23. And it's marked, yes, CCJ.
Is it what? The proceedings before the Court of Appeal or before Mr. Justice Abel?
It's before the Court of Appeal. It says CCJ, BZCV2023/003. That is where I got it from.
No, I don't think you're catching what I'm saying. Is it, are they the proceedings of the Court of Appeal or of the proceedings before Mr. Justice Abel that you're citing from?
Proceeding before Mr. Justice Abel.
Okay. And you said we'll find that at 3975.
That's where I have it. Also, to my lords, the appeals to the CCJ or to the Court of Appeal are all based on the evidence that was elicited before the trial judge of court of first instance. So every appeal involving matters of fact are dealt with at the appellate court, at the highest court, and it's the same evidence that was before Justice Abel, went before the Court of Appeal, and now is before your lordship. In other words, there is no rational purpose for anyone to want to try to appeal against two separate decisions because it's the same decision you're appealing against. The facts are the identical facts that were before Abel, that is now before Abel J, that is now before your lordship, that was before the Court of Appeal. So it's not that the appeal, the requirement to amend it is not because I am confused as to and want to have two appeals. That is never the case. It's the same facts before your lordship. The issue as to the affidavit of Carla Barnett, of Carla Sebastian, the first I heard of that, and I'm only giving you my evidence, my experience. The first I heard of it was at the end of the submission in the case before Mr. Justice Abel. I never heard of it before, never. And there is nothing on the record that shows that, in fact, we were made aware of it and had an opportunity to opine on it. Nothing.
Mr. Elrington, pause.
Yes.
I need to understand something. Did you make an application to give evidence by video?
No, my lord, I never did. The application to give evidence by video was made by the other side.
All right, sorry. So did the other side make an application to give evidence by video?
They did.
Did that happen before the trial?
It happened before the trial.
In that application, was the affidavit of Carla Sebastian filed?
If it was filed, I don't know, my lord, but I can
Oh,
tell you
Mr.
definitely not-
Mr. Elrington, this is a question of the
Yes.
record of the court.
Yes, but
The
I'm
other
saying it
side
was
makes an
not-
application to give evidence by video. They say they filed an affidavit in support. Is that so or not so?
I cannot tell you because it never came across my desk. I never saw it. It was never served on me.
It was
Normally,
never
when one-
it was never served on you. So
never.
did you all right, pause. You say it was never served. Did you ever participate in that application?
In which one?
For them to give evidence by video.
Yes, I vigorously participated in it, your lord.
So you participated in the application. Fair
Yes.
enough. Right. So forget about whether you were served or not. In that application, as a matter of the court record, was the affidavit of Carla Sebastian a part of that application? Don't tell me what you knew. No, it was not.
My lord, it was not a part of that application. It was never raised. I never saw it then.
All right. So let me try a different angle. Was there an affidavit of Carla Sebastian filed in these proceedings?
My lord, I can say with candor that at some time an affidavit was filed in the registry.
And
but I never knew of it until at the end of the proceedings before Mr. Justice Abel at the closing argument of counsel.
I have made a note of that. I have made a note of that. I'm just trying. Now you see, I suppose I'm confused. I don't know if my brothers and sisters are clear, but I am confused. I thought that we were told that the affidavit of Carla Sebastian was part of the application for the use of video evidence.
Absolutely not.
Not.
Absolutely
Okay, you say
not.
no. Fair enough. I can only record. All right, I can only record what you say. All right.
Yes.
Good. Let's move.
Yes. All right.
You have 3 minutes, Mr. Elrington.
Yeah. All right. So the decision clearly that we were appealing against was the decision of the Court of Appeal. The issue of authority was for the other side, and the issue came up ex improviso. I had no previous knowledge that this issue of authority would have turned out the way it did. Had none, because I have no knowledge of the inner workings of the company. There was no ambush. At no time was there an ambush, but on my part. And what I was doing was cross-examining, which is in fact the responsibility of counsel to cross-examine based on evidence that is given in the court. So my lord, it seems as if I have covered most of the issues, unless your lordship should go into here. Boris, if you have an issue.
Yes. No, we're good. Ms. Bang, there's a document that you promised to make available to us or to point us to.
Yes, Your Honor. Your Honor, there are two things. The trial was held on the 17th, 18th, and 19th of September 2019.
Yes.
And Your Honor, in terms of the transcript for the hearings, the transcript runs quite a few pages, Your Honor. It
Are they
is.
filed at the CCJ? Do they have CCJ page numbers?
It appears not, Your Honor, but there are 728 pages in the transcript. And this is a transcript for those 3 trial days, and there's a certified copy here from 4 court stenographers who worked on the transcript, because it was quite a lot of cross-examination.
Okay,
And
just now. If they have not already been filed, can we rely on you and Mr. Elrington to agree that these represent a certified copy of that transcript and that they be filed?
Your Honor, we would ask the permission of the court to file it. It already has the signatures in original of the 4 stenographers, and it was shared. I believe it was filed in the Court of Appeal. It was just not included in, I suspect, because I'm not seeing it in the bundle.
When can you have it filed? By what
Within
time?
10 minutes, Mr. President.
Okay, so we give you leave to file those by tomorrow at the latest.
Mr. President, can I ask that because it's so voluminous, the parts we are interested in are very narrow, I think. So I don't know if we can get a notation as to where they are in this transcript, so we don't have to read the entire transcript, or if they be highlighted or something. Yes. I don't know what is most efficient.
Mr. Elrington, this goes for you as well, because I think that the documents that you filed today or late yesterday referenced those transcripts, and you refer to them in your submissions. And so if you could file another document identifying the page numbers of that transcript which you are referring to, and similarly you, Ms. Banner, and you would both do so by tomorrow at the latest.
Much obliged, Mr. President. I'm going to work on it.
Thank you to both of you for your submissions to us.
Your Honor, if I may, Your Honors, the transcript, you should see those pages where Mr. Schneider stated that that we do have resolutions prepared by Courtney Coye. You should see those at page 335 of the transcript, but I will look through the entire thing to list for the court all those pages that deal with the reference by Mr. Schneider.
Just a minute. That's page 335 of the transcript that you are going to file?
Yes, Your Honor.
No, well, don't tell us that. No, tell us that in a document that you would prepare when you file it, asking the court to reference particular pages.
Yes, Your Honor. And I must apologize to the court. We appreciate that the record could have been neater, and we participated in that process. So I do offer my apologies. We will certainly be very careful in the future to ensure that these things are filed properly.
Yes, well, thank you. I really appreciate that.
Mr. President, can you repeat exactly what you want of us? Because I am not clear what you want.
Well, you see, in your submissions a short while ago, and I think in also the documents that you filed this morning or late yesterday, you referenced that transcript, if I'm not mistaken.
The transcript in which Mr. Lawrence Schneider replied on the cross-examination, is that one you want?
The transcript of the trial proceedings.
Yes, in which, yes, because that is what but the learned judge is asking. He doesn't want to go through a whole 700-page document.
Exactly. So all I'm asking, Ms. Banner is going to file that transcript. And I'm asking you if there is material in there that you would like us to look at. If in a document, one page, that you can refer the court to the page numbers that you think are relevant and important to your case. We don't want any argument. We don't want any narrative. We just want you to indicate page numbers that you think are relevant and important to your case.
Very good. Very good, my lord.
Yeah.
President, can I intervene with one other thing? Do we have, as a matter of the record, the application for for permission to give evidence by video, which if I'm wrong on this correctly, which I believe, Ms. Banner, you said included as part of that application the affidavit of Carlos Sebastian?
Your Honor, to be clear, the claimant filed the application with an affidavit in support of Mr. Schneider. That was the affidavit that counsel then responded by affidavit to say that there's no evidence before the court because Mr. Schneider is not authorized to depose to that affidavit. And then we responded in reply.
No, I understand. I understand. You see, what I want to know is, do we have that package? Do we have the application, the Schneider affidavit in support, Mr. Elrington's affidavit in response, and your affidavit in reply? We need to see that bundle of documentation, because we've been told things about not being aware and never been served before and so on and so on. So that's what we want to see. We want to, if we don't have it, Mr. President, I think that could be helpful to us to have.
Ms. Banner?
Yes, Your Honors. I am just checking because there are two separate bundles. I am just very quickly checking, but certainly we can deliver that to the court today also, if the court would give us permission to submit that.
Yes. By all means.
And you have until tomorrow.
Yes.
You have until tomorrow.
Much obliged.
Anything that you file, naturally, the other side, you will make sure that they are aware that it is filed.
Much obliged.
Okay, so we want to thank you both for your submission on this very interesting matter. Naturally, we will reserve our decision and we will let you know when it will be ready for publication. So thank you very much. And Madam Deputy Registrar, you may close the proceedings.
Much obliged.
Much obliged.
Thank you. Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Javada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.